to the Kenneth Verkaman Law Office Legal Podcast. In this edition, we explain powers of attorney. Now, many people have wills, and you don't need to be rich or near death to have a will. It's important to have a will because the will sets forth if you pass away, who's going to be your executor, that bills be paid, and how your assets are distributed. But not enough people do any sort of proper planning for becoming disabled. Now, similar to dying, people don't plan on becoming disabled, but people get in accidents, they fall down steps, they break arms, they break legs, and they're temporarily disabled. So it's a good idea for people who have a house or have kids to have a power of attorney. With a power of attorney, you are giving someone the power to make sure that your bills are paid, that all your accounts are handled properly. And for most married people, they make their spouses for the power of attorney. And then another family member. If someone doesn't have a close family member, they can pick an attorney that they trust or accountant that they trust. Now, there's two types of power of attorney. One is power of attorney that's effective right away. That's called a durable power of attorney. Other powers of attorney are only effective if someone becomes disabled. That's called a springing power of attorney because that becomes effective. It springs into effect when someone becomes disabled. But it's also important to do these while summoned as well, because my office often gets calls by someone saying, listen, I need to get power of attorney from my mom or from my uncle. Okay, well, when can they come in? Versus, well, they can't, they had a heart attack or stroke. I guess, well, are they competent now? Because we can't prepare a document for someone else. We have to prepare it for the person who is ill, and we really need to talk to them first and make sure that's what they want, not that some relative is just trying to get control over their finances. If they wait too long and the person is not competent, then the family has to go through this very expensive, embarrassing procedure called the guardianship, where you're asking a court to declare someone incapacitated and basically incompetent, which used to be the old standard. So these powers of attorney, you meet with your attorney, you indicate who you want as executor 1, executor 2, prepare the documents, and they're signed. The cost is under $200, and that's a big bargain considering that the cost for doing a guardianship could be over $4 grand. For other information on powers of attorney, visit website njlaws.com or website Central Jersey Elder Law. You can also, for representation and preparation of documents, contact the Law Office of Kenneth Verkaman at 732-572-0500. Thank you and good luck.